Sign the transfer papers, Dustin, unless you want to explain to your wife why you're unemployed. Jeremy Harlan slid the demotion notice across the conference table with the smug grin of a man who thought he'd already won. I looked at the document, then at the three other people in the room. Sandra from HR clutching her termination folder, Victor Eng, our CFO, lounging like he owned the building, and Patterson, our nervous legal counsel, who wouldn't meet my eyes. "Before I sign anything," I said, pulling a sealed envelope from my briefcase, "you should read this." The envelope hit the table with a sound that might as well have been a gunshot. My name is Dustin Caldwell, 36 years old, Senior Director of Contract Strategy at Greystone Industries. On a Wednesday morning at 9:47, I walked into conference room 12 knowing they planned to destroy my career. What they didn't know was that I'd spent 4 years building the perfect trap, and they were about to spring it themselves. 4 years. Ago, Greystone acquired Redfield Systems in a messy $11 billion merger. I was brought in to harmonize thousands of contracts, navigate regulatory landmines, and make sure the integration didn't implode. The workload was crushing. I practically lived in those documents for 18 months. But buried in the merger paperwork, I found something beautiful. An executive incentive pool worth $85 million designed to reward key employees who identified major compliance risks. The fund sat in escrow, barely monitored, waiting to be distributed over 7 years. That's when opportunity knocked. I was negotiating my promotion to senior director as part of the restructuring. Legal was drowning in paperwork. HR was overwhelmed. The outgoing chief counsel, Richard Stokes, was counting down his last 60 days until retirement and signing everything placed in front of him. "I need enhanced protections," I told him during our contract review. "I'll be evaluating executive-level deals worth millions. If I uncover something serious and face backlash, standard indemnification won't cut it." Richard barely glanced up. "Draft something reasonable and get it approved." Reasonable. That word has always been wonderfully vague. I crafted what I called the Executive Accountability and Protection Provision. If I filed a formal compliance warning about financial irregularities exceeding $15 million and the company responded with demotion, termination, or isolation within 45 days without resolving the underlying issue, I would receive the entire executive incentive pool as immediate compensation. The genius was in the structure. I didn't bury it in my employment contract where it might get scrutinized. Instead, I created a side letter to the incentive plan requiring only CEO approval and compensation committee sign-off, not full board review. Then, I established an irrevocable escrow arrangement with Continental Trust Bank. Once the triggering conditions were verified by the escrow agent, funds would release automatically from designated reserve accounts. No manager approval needed, no way to reverse it. The CEO, Lawrence Briggs, signed it without reading past the title. The compensation committee approved it in a batch with 53 other incentive modifications. Richard stamped it with legal's blessing, probably thinking about his retirement golf plans. I filed the executed documents with Continental Trust, sent certified copies to my attorney at Rothman & Vale, and locked the originals in a safety deposit box. Then I waited. For 4 years, I was exemplary. Stellar reviews, 2 promotions. I even won the Chairman's Circle Award for contract optimization. All while knowing I carried a $62 million insurance policy that would detonate the moment someone tried to silence me. Because in companies this size, someone always gets greedy. 22 months into my senior director role, I found the thread that would unravel everything. It started with a routine. Vendor audit. Obsidian Solutions, a data security consultant charging us $850,000 monthly for advanced threat monitoring services at our Memphis facility. The amount wasn't unusual for enterprise security, but something felt wrong. I pulled their incorporation records. Delaware LLC formed 19 months ago. No website, no industry certifications. The registered address was a mailbox service in Wilmington. Then I checked the payment approvals. Every invoice bore Victor Eng's electronic signature, processed within 4 hours of submission. Always Victor, never delegated, never rotated through approval chains. That's when I found the connection. Buried in Delaware Secretary of State filings, Obsidian Solutions registered agent, was Eng Capital Management, the same entity listed in Victor's executive disclosure forms as his personal investment vehicle. Our CFO was paying himself $850,000 monthly through a shell company. I traced 3 years of payments, $30.6 million split across multiple budget codes to avoid detection. Classic embezzlement technique. But Victor had gotten sloppy. The invoices contained identical typos month after month. Email threads showed him explicitly instructing accounting to bypass normal review procedures. I documented everything. Purchase orders that didn't match our system, bank routing numbers that traced back to offshore accounts, even found building inspection records proving our Memphis facility never upgraded its security systems. The invoices were complete fiction. I prepared a 42-page formal compliance alert, complete with financial flowcharts showing money moving from Greystone to Obsidian Solutions to Eng Capital Management. Filed it with the Ethics Committee on a Monday morning, copying the audit chair, legal, and HR per protocol. Jeremy Harlan's retaliation was swift and vicious. By noon, Monday, my system access was restricted for routine security updates. By 3 p.m., I was excluded from the executive strategy meeting due to agenda constraints. By end of day, 3 of my direct reports were reassigned to higher priority initiatives. Tuesday morning, Jeremy called me to his corner office. The space felt designed for intimidation, all glass and steel overlooking the city. "You're playing a dangerous game," he said, not bothering with pleasantries. "I'm following compliance protocols. You're overstepping your authority. Vendor oversight isn't your domain. Contract compliance is exactly my domain. $30 million in questionable payments requires investigation." His smile was pure predator. Employees who don't understand their place in the hierarchy tend to find themselves reassigned to less prestigious roles. I documented everything. Every restricted access, every canceled meeting, every threat, time-stamped emails to my personal attorney at Rothman and Vale, building an evidence trail that would hold up in any courtroom. Wednesday brought more surgical strikes. My corporate card was frozen for unusual activity review, despite 0 charges. My parking spot was reassigned. My email mysteriously failed when sending to audit committee members. Thursday, HR scheduled a performance coaching session. Sandra's plastic smile couldn't hide the hatchet she was sharpening. "Your last review was exceptional across all metrics," I noted. "Recent observations suggest collaboration challenges and cultural misalignment," she replied smoothly, sliding a performance improvement plan across her desk. 30 days to demonstrate enhanced team dynamics and strategic alignment. The goals were impossibly vague, designed to fail. I signed the acknowledgement, then photographed every page with my personal phone while she pretended to check her calendar. Friday afternoon, I filed my formal notice of escalation with Continental Trust Bank, not just the informal alert I'd sent to the Ethics Committee. This was the legal trigger outlined in my protection provision, sent via certified mail, to the bank, the board secretary, and my attorney. The clock officially started ticking. Over the next 2 weeks, they executed their character assassination with corporate precision. Meetings scheduled 30 minutes in advance across campus. Critical emails arriving at 5:07 p.m. Friday, requiring Monday morning responses. Projects reassigned without notice, then questioning me about missed deadlines for work I no longer owned. But Sandra made a crucial mistake. She documented everything in her vendetta folder. Late to a meeting she scheduled during my approved medical appointment. Failed to respond to an email sent to my disabled account. Missed training for a session that was never scheduled. She thought she was building my termination file. She was actually building my evidence package. Meanwhile, I discovered the scheme went deeper. My contact in payroll, an analyst named Rita Voss who was fed up with executive corruption, slipped me documentation showing $38 million in suspicious retention bonuses paid to unnamed consultants, all routing through the same Delaware banks as Obsidian Solutions. Victor wasn't just stealing, he was running a full kickback scheme involving at least 6 executives. Then, our night security supervisor, Marcus, pulled me aside in the parking garage. Saw something interesting last Tuesday. 2:30 a.m., Mr. Eng loading boxes into an unmarked van. Personally, 23 boxes, had to disable the dock camera for maintenance. He was sweating like a man burying evidence. By the time Wednesday morning arrived, I had everything. The embezzlement trail, the kickback network, the evidence destruction, even found the fake invoices Victor created to backfill the Obsidian payments, all using the same PDF template with identical metadata timestamps. Amateur hour. That's when I received Jeremy's meeting invitation. DC discussion, Confroom 12, 9:45 a.m. Wednesday. The subject line might as well have read, "Your execution." I sent one final package. To the Securities Enforcement Division, 500 pages of evidence, corporate structure diagrams, bank records, the complete roadmap to $38 million in stolen funds. Then, I dressed for war. My best suit. The Mont Blanc pen I'd bought after closing the Redfield deal. At 9:44, I stood outside Conference Room 12, watching through the glass as Jeremy practiced his victory speech. At 9:45 sharp, I walked into my $62 million moment. The moment I entered, I knew they'd choreographed this like a corporate execution. Jeremy at the head of the table, fingers steepled. Sandra with her termination folder spread open, signature flags visible. Victor sprawled with the casual arrogance of a man who'd stolen $38 million and considered it a rounding error. Patterson clutching his legal pad like a drowning man. "Dustin," Jeremy began, voice dripping manufactured sympathy, "we've tried to make this work, but your continued disruption. You mean my compliance alert regarding $30 million is fraudulent payments?" Victor's jaw tightened. "Alleged. That matter has been reviewed internally." "By you? How thorough?" Sandra jumped in, sliding the demotion notice forward. "We're offering a final opportunity. Accept transfer to associate-level contract analyst under Martin Webb, or we proceed with termination for cause." I didn't touch the paper. Instead, I placed my phone on the table and pulled out the sealed envelope. "Before we continue, there's something you need to understand. 72 hours ago, I notified Continental Trust Bank that adverse employment action was imminent following my unresolved compliance alert. They're standing by for confirmation." Patterson's pen froze mid-stroke. "What are you talking about?" I opened the envelope, revealing the cream-colored document with Continental Trust's watermark. 4 years ago, I negotiated a specific protection provision. If I report executive malfeasance exceeding $15 million and face demotion or termination within 45 days before the issue is resolved, I receive $62 million from the Merger Incentive Fund. "That's insane," Jeremy sputtered. "Nobody would approve." Page 9, Section 6, signed by CEO Briggs, approved by the Compensation Committee 4 years ago, funded through irrevocable escrow instructions with Continental Trust Bank. I dialed the bank on speaker. 2 rings. "Continental Trust Services, Corporate Escrow Division, this is Barbara Lewiston." "Ms. Lewiston, Dustin Caldwell, verification code Alpha 77 Delta. I need immediate confirmation of trigger status on the Greystone Industries accountability provision." "Good morning, Mr. Caldwell. I show your anticipatory notice was received 72 hours ago. Can you confirm the adverse employment action has occurred?" I looked at the demotion letter. "I'm being offered a demotion to associate analyst reporting to a manager with 8 months tenure. The alternative is termination. Is this in response to your formal compliance alert filed October 3rd? "Correct. The underlying issues remain unresolved." Keys clicked. "Please hold while I verify trigger conditions." The room erupted. Victor slammed his fist on the table. "Cut that call immediately." "That won't stop the escrow release," I said calmly. "The instructions are irrevocable." Patterson frantically opened his laptop. "I need to see this contract. This has to be void or superseded." "Mr. Caldwell," Barbara's voice cut through the chaos, "I've confirmed all trigger conditions are satisfied under Section 8.4. Constructive termination following a compliance alert qualifies. The $62 million disbursement will process within 1 business day. This is Victor Eng, CFO. Cancel that transfer immediately. No funds move without my authorization." "I'm sorry, sir, but these are irrevocable escrow instructions executed 4 years ago. The funds are held in a segregated account outside Greystone's operational control. Once triggered, the company has no authority to block the transfer. I pulled out a second folder. While we're all here, I should mention the Securities Enforcement Division received complete documentation of the Obsidian Solution Scheme this morning, along with evidence of $38 million in executive kickbacks routed through Delaware shell companies. Victor's face went from red to ash. Additionally, I continued, my attorneys at Rothman and Vail have maintained complete backup copies of all relevant documents under litigation hold. Oh, and Victor? Loading 23 boxes into an unmarked van at 2:30 a.m. was sloppy. Marcus says hello. Jeremy stood so fast his chair toppled backward. You can't do this. I didn't do anything. You did. Every retaliatory action, every vindictive move, every attempt to silence me. You built this case yourselves. I just documented it. My phone buzzed. Email from Continental Trust. Disbursement initiated. Expected completion Thursday 11:02 a.m. Eastern. I stood, buttoning my jacket. Gentlemen, Ms. Durant, you have one business day to explain to the board why your former senior director now owns $62 million of shareholder money. I suspect they'll have questions. As I reached the door, Victor's voice cracked. Wait, we can negotiate this, work something out. I turned back. The time for negotiation was when I reported $30 million in fraud. You chose retaliation instead. Enjoy explaining that choice to the federal investigators. The last thing I saw before the door closed was Patterson frantically calling the legal department, Sandra's manicured nails digging into her folder, and Jeremy staring at the demotion letter like it had transformed into a viper, which, in a $62 million way, it had. The counterattack came within 90 minutes, desperate and chaotic. I was loading my personal items into my car when Patterson called. Mr. Caldwell, the executive team is willing to discuss a resolution. The resolution is already processing through Continental Trust. That provision can't be valid. It's unconscionable. No court would uphold. Then you have nothing to worry about. See you in court, Patterson. By noon, they shifted from threats to bargaining. Sandra left 4 voicemails, each more strained. Dustin, there's been a misunderstanding. Your position is secure. We can resolve this internally. Too late for that dance. At 2:15, I received a cease and desist from their outside counsel, demanding I halt the improper escrow release. They claimed the provision was void due to material misrepresentation and violation of public policy. I forwarded it to my attorney with one note. They're panicking. His response came in 12 minutes. This reads like a first-year law student's panic attack. The notarized signatures and committee approval are ironclad. They're grasping at straws. Victor tried the direct approach at 3:30, calling from an unknown number. $62 million is excessive, Dustin. Be reasonable. Reasonable like stealing $30 million through shell companies? That's under investigation. But this nuclear option helps nobody. The board will fight. Shareholders will sue. You'll spend years in litigation. Will I? Because Continental Trust doesn't seem concerned. The funds are already allocated. Silence. Then, what do you want? I wanted a company that didn't retaliate against employees for reporting fraud. That ship sailed when you tried to bury me. We can undo that. Full reinstatement. Back pay. I'll recommend you for VP. The same VP position you dangled 2 years ago before you needed a scapegoat? I understand perfectly how this world works, Victor. You thought I was just another corporate drone you could bulldoze. Surprise. He hung up. At 4:30, my attorney called with the real news. Heads up, Greystone just filed an emergency motion in Delaware Chancery Court seeking a temporary restraining order to freeze the Continental Trust disbursement. On what grounds? Everything they could think of. Breach of fiduciary duty, unjust enrichment, fraudulent inducement. They're claiming you engineered this situation to trigger the provision. I actually laughed. I engineered Victor stealing $30 million? It gets better. They're claiming the signature pages were forged despite having notarization and board minutes confirming approval. They've hired Carmichael and Ross, major firm with serious political connections. Full scorched earth. Good. Let them waste their money. What's our response timeline? Already drafting. But Dustin, this could get ugly. It's already ugly. At least now it's expensive for them too. The most interesting call came from Barbara Lewiston at Continental Trust, using her personal cell. Mr. Caldwell, I shouldn't be calling, but you deserve to know. We received the injunction request. Our legal department reviewed it thoroughly. She paused. We're proceeding with the disbursement as scheduled. The escrow instructions are crystal clear. Frankly, we'd face liability if we didn't honor them. The Delaware court can sort out the aftermath, but our obligation is to follow the original agreement. Thank you, Barbara. Thank you for including such precise instructions 4 years ago. It's the cleanest trigger provision I've seen in 23 years of fiduciary banking. I poured a bourbon that evening, the good stuff I'd been saving, and opened my laptop to watch the fireworks. The company-wide email from the chairman hit at 6:47. Emergency board meeting scheduled Saturday 9 a.m. Mandatory attendance, executive session to follow. Perfect. Panic makes people sloppy, and sloppy people make 62 million mistakes. Friday night, while Greystone's executives huddled in crisis meetings, I worked with my attorney to prepare for the inevitable. They filed a supplemental brief claiming I had insider knowledge of the Obsidian scheme and failed to report it timely, despite my formal alert dated October 3rd. I sent, over my meticulous timeline, email dated February 18th, initial inquiry about new vendor approvals. March 11th, follow-up requesting vendor documentation. April through September, 23 separate requests for Obsidian contracts, all ignored or deflected. Send these over, my attorney said. We'll bury them in their own paper trail. By 11:15 p.m., desperation reached new heights. Lawrence Briggs, the CEO who'd originally signed my provision, called from his personal number. Dustin, I'm calling to understand how we got here. You signed an accountability protection provision. Your CFO stole $30 million. Your management retaliated when I reported it, cause and effect. That provision was never meant to be used. Then why did you sign it? Long silence. We thought it would encourage whistleblowing, show we were serious about compliance post-merger. Congratulations, it worked exactly as designed. 62 million, Dustin, that's devastating for a company our size. 30 million in theft wasn't devastating. 38 million in kickbacks didn't concern you? What if we offer 55 million? Clean settlement, mutual releases. Everyone moves on. The bank processes Thursday at 11. That train has left the station. Trains can be stopped. Not this one. Here's free advice. Instead of fighting me, ask why your CFO is loading boxes at 2:30 a.m. I hung up and let him chew on that. Saturday morning arrived clear and cold. I dressed carefully. Charcoal suit, minimal accessories. If they wanted war, I'd attend the funeral. At 9:30, my attorney called. You need to hear this. Greystone's filing an amended complaint about improper escrow funding allocation. 3 years after the fact, they're desperate. There's something else. Victor Eng was arrested this morning. FBI raided his home at 5:45 a.m. Wire fraud, tax evasion, conspiracy. Someone sent them a very detailed evidence package. Imagine that. Dustin, please tell me you didn't. I reported financial crimes to appropriate authorities. Isn't that what a compliance officer does? At 10:15, I joined the emergency board meeting via secure video link, my right as a material party to the dispute. The boardroom looked like a disaster command center. 11 directors in various states of panic. Emergency counsel lined against the walls, and at the center, empty chairs where Victor should have been. Chairman Gregory Tate called for order. Mr. Caldwell, you're connected. Present, Mr. Chairman. Given this morning's developments, we need to discuss immediate resolution. Jeremy, sitting to Tate's left, looked like he'd aged a decade overnight. She orchestrated this. The FBI raid, the timing. Mr. Harlan, Tate cut him off sharply, the FBI doesn't raid CFOs because of disgruntled employees. They raid them because of evidence. The 62 million, someone started, is processing Thursday per legal escrow instructions, I interrupted. However, I'm prepared to discuss the path forward. Every head turned to my video feed. The accountability provision was designed to protect employees who report malfeasance. I reported. You retaliated. The provision triggered. That's done. But Greystone has bigger problems than my settlement. I shared my screen, showing a simple spreadsheet. Based on public filings and my documentation, you're facing minimum 8-figure liability from the Obsidian fraud, potential shareholder lawsuits, regulatory investigations, criminal exposure for any executive who knew and stayed silent. Are you threatening us? Someone asked. I'm offering clarity. You can spend millions fighting my lawful contract claim while your company burns, or you can accept that actions have consequences and focus on actual crisis management. The room erupted in crosstalk. Tate pounded his gavel. Enough! Mr. Caldwell, what exactly are you proposing? I laid out my terms with surgical precision. First, the $62 million processes as scheduled, non-negotiable. Continental Trust confirmed they'll proceed regardless of court filings. Fighting it wastes legal fees you'll need for the federal investigation. Second, immediate termination of Jeremy Harlan and Sandra Durant for orchestrating retaliation against a whistleblower. That's criminal under Sarbanes-Oxley. Third, full forensic audit by an independent firm. I suggest Kincaid Associates. They specialize in fraud recovery. Every executive transaction, every vendor relationship, every offshore account. Clean house or watch it burn. Fourth, full cooperation from remaining executives. I have documentation proving the board was kept in the dark. That makes you victims, not accomplices. But only if you act decisively now. Tate called for a recess. Let them stew in their fear while the clock ticked toward Thursday's wire transfer. When they reconvened 20 minutes later, the atmosphere had shifted from adversarial to pragmatic. Mr. Caldwell, Tate began, carefully. The board has discussed your proposal. We're prepared to accept your terms with modifications. The $62 million will process. We acknowledge we cannot stop it. Harlan and Durant will be terminated for cause effective immediately. We'll engage Kincaid Associates for comprehensive audit. The general counsel, Patricia Raines, leaned forward. In exchange, we need complete cooperation, all documents, all evidence, full testimony if required. And we'd like you to consider a consulting arrangement to help us unwind this mess. Your knowledge of our contracts is unique. 6-month consulting agreement, $850 per hour, full indemnification. I report only to the board. And the employees who help me, Rita Voss, Marcus, and others, full whistleblower protection. Any targeting of my sources voids our agreement and triggers another $62 million penalty. Tate winced but nodded. Agreed. Then we have a deal. Have Patricia draft the agreements. I'll sign once the wire confirms Thursday morning. As board members began disconnecting, Tate stayed on. Mr. Caldwell, one question. When you negotiated that provision 4 years ago, did you anticipate this? I anticipated that eventually someone would try to silence me for doing the right thing. I just made sure it would cost them when they did. $62 million. Hell of an insurance policy. No, Mr. Chairman, it's the price of integrity. Your company just learned what happens when you undervalue it. Thursday morning arrived with poetic precision. At 10:58, I sat in my home office, laptop open to 3 screens. My bank account, Continental Trust's wire confirmation system, and Greystone's stock price, down 18% in pre-market trading. At 11 sharp, my laptop chimed. Continental Trust Bank, wire transfer completed, $62,000 Notzahlen credited to account ending in 7/43. Reference, Executive Accountability Provision Settlement, $62 million, 9 digits that transformed 4 years of planning into permanent financial freedom. I dialed Patricia Raines. Confirmation received. Congratulations, Mr. Caldwell, though I suspect we should be thanking you. The FBI served additional warrants this morning. Your documentation led them to 5 more executives involved in the kickback network. Just doing my job. The job Jeremy tried to punish me for. Speaking of which, his termination was eventful. He threatened to sue until we showed him your evidence file. Legal says he actually went pale. And Sandra? Cleaned out her office at 5:30 this morning, trying to avoid security. She was unsuccessful. By noon, my phone exploded with messages. Board members suddenly remembering my name. Reporters sniffing around the edges. Former colleagues choosing sides. But the most important message came from Rita Voss. Just got promoted to senior analyst, full protection. They're too scared to even look at me wrong. Thank you for showing us how to fight back. I stood on my balcony, overlooking the city where I'd spent 4 years playing corporate chess. Somewhere in those gleaming towers, other employees were being bullied, silenced, punished for doing the right thing. But maybe some executive would remember my story before retaliating against a whistleblower. Maybe some HR director would think twice before building a false performance file. Maybe some CFO would realize the person documenting their crimes might have documented protection too. 62 million. Not a bad price for a lesson in respect. I raised my glass to the city, to everyone who'd been crushed by corporate power, to every contract that could be both weapon and shield. Tomorrow I'd walk back into Greystone Industries as a consultant, helping them clean up the mess they'd created. But today, I was exactly where that demoted associate analyst was supposed to be, sitting on a fortune they'd handed me themselves, one signature at a time. Sometimes the best contracts are the ones nobody bothers to read. Thank you so much for listening to this story of corporate revenge and justice. I'd love to know where you're tuning in from. Drop a comment below and let's connect over our shared thoughts about Dustin's incredible journey. If you enjoyed this tale of contracts and consequences, please hit that subscribe button and give this video a like. And if you really want to help more people discover this story, share it with someone who needs that dose of justice in their day. Until next time, remember, always read the fine print.